6 justices, 3 dissenters. One decision that flipped concealed carry law upside down in America. And most gun owners still do not understand what it gives them. And now in 2026, that same ruling is about to drop a second bomb. One that could wipe out every restriction your state slapped on you after that first ruling hit. Look, I spend hours every week digging through Supreme Court decisions, legal briefs, and court transcripts so you do not have to. The least you can do is hit subscribe to Gun and Gavel right now and join the gun owners who get this information first. Because what I am about to break down could change where and how you legally carry, and whether you're doing it right today. Subscribe to Gun and Gavel now. Then let us get into it. Here's what just happened and why it matters right now in 2026 than the day it was decided. The case is called New York State Rifle and Pistol Association v. Bruen. The Supreme Court decided it on June 23, 2022. The vote was 6-3. And if you are a concealed carry permit holder or someone thinking about getting a permit, this ruling changed your world. Most people heard about it. Very few understood it. Let me break this down for you from the beginning. Before Bruen, there were roughly 8 places in this country, 7 states plus Washington, D.C., where getting a concealed carry permit was impossible for ordinary people. We're talking New York, California, New Jersey, Hawaii, Maryland, Massachusetts, Rhode Island, and D.C. These places all had what is called a may issue system. That is the legal term for it. And here's what it means in English. It means a government official got to decide whether you personally needed a gun. Not whether you were qualified, not whether you passed a background check, whether in their opinion you had a special reason to carry. If you said, "I want to protect myself," most of the time they said no. Think about that for a second. You're a law-abiding citizen. You passed a background check, you took a safety course, you did everything right. And some official with a desk job in Albany or Trenton gets to sit there and say, "You know what? I do not think your reason is good enough." That was the reality for millions of Americans before June 2022. Then the Supreme Court stepped in, 6-3, and said, no, that system is unconstitutional. Under the Second Amendment, you have the right to carry a handgun outside your home for self-defense. And a government official cannot just veto that right because they personally disagree with your reason for wanting it. But here is the crazy part, and this is where the story starts. The ruling did not just change New York because of the way it was written. It changed the legal test for every gun law in America. They have to prove that restriction is rooted in America's history and tradition of gun regulation going back to the founding era. That is a different legal standard, and it has been rocking the lower courts since. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Gun laws vary by state, and a licensed attorney in your state is the right person to answer specific questions about your carry rights. What I am giving you here is the big picture, so you can be an informed gun owner. Back to it. Here's the part nobody is talking about. After Bruen came down, the states that had been running may-issue systems did not just give up. They fought back hard. New York passed something called the Concealed Carry Improvement Act weeks after the ruling. They could not say no to your permit anymore based on vague reasons. So instead, they created a list of places where you cannot carry at all. Subways, restaurants that serve alcohol, Times Square, most of New York City. They tried to shrink where your permit was valid down to almost nothing. New Jersey, California, Maryland, they all did similar things. They passed laws defining so-called sensitive places where concealed carry is prohibited. And the lists got long very fast. Here is a hypothetical example to explain what this looked like in practice. Imagine you live in New Jersey. You finally get a permit after Bruen. You are excited. You are legal. You strap on your firearm. And then you realize that every place you go, the grocery store, the movie theater, the transit system, the park, is on a list of places where your new permit does not apply. You have a permit, You just cannot use it almost anywhere you actually go. That was the reality many gun owners were living after states hit back at Bruin. If you are finding this helpful, here's a heads up. My next video is going to cover the specific language you should use when law enforcement asks whether you're carrying. There are 5 words that can make all the difference during a traffic stop or encounter. Subscribe to Gun and Gavel right now so you do not miss that one. That video could be more important than anything I put out this year. Now, this is where it gets interesting, because everything I just described, all of that state pushback, is now being tested again. There is a case sitting at the Supreme Court right now called Woolford versus Lopez, and this is the case that is going to determine whether the states got away with their counterattack after Bruin. Here is what the case is about. After Bruin, Hawaii passed a law saying that if you have a concealed carry permit, you cannot bring your firearm onto private property that is open to the public. Things like restaurants, bars, shopping centers, parking lots, banks, unless the property owner gives you explicit written or verbal permission to do so. The people covering this case started calling it the vampire rule, because under it, you need to be specifically invited in with your gun before you can enter. Like the old vampire folklore where a vampire cannot enter a home unless the owner invites them. That is how strict it is. Gun owners in Maui, Hawaii sued. The case went up through the courts. The Ninth Circuit upheld Hawaii's law, and on October 3rd, 2025, the Supreme Court was petitioned to hear it. Oral arguments were set for January 20th, 2026. 2 hours of argument. And here is what every major legal reporter said after watching it. The conservative majority, all 6 Republican-appointed justices, appeared to side with the gun owners. Chief Justice John Roberts reportedly said that the Second Amendment has been treated as a disfavored right in the courts compared to other constitutional rights. Justice Samuel Alito told Hawaii's lawyer that the state was relegating the Second Amendment to second-class status. Justice Neil Gorsuch questioned why the government gets to redefine property rights in ways that specifically gut your constitutional rights. Justice Brett Kavanaugh basically said, if the text of the Second Amendment covers this, and there is no historical tradition supporting Hawaii's restriction, that should be the end of the case. Even the Trump administration argued against Hawaii in this case, with the government's lawyer telling the justices that if Hawaii wins, states could start banning tenants from owning guns without their landlord's consent. Hey, quick heads up. The vast majority of people watching this video right now are not subscribed to this channel. That means when the Woolford decision drops, a ruling that could directly change where your concealed carry permit works, they are going to miss the full breakdown. Do not be that person. Join the tens of thousands of gun owners who rely on this channel for no-nonsense legal updates. Hit subscribe to Gun and Gavel right now. It takes 2 seconds. Now let me tell you why the Woolford decision matters for you specifically wherever you live. This is not a Hawaii problem. Hawaii was just the test case. States like New York, New Jersey, California, and Maryland all passed similar laws after Bruin. They all created lists of privately owned places open to the public where you cannot carry. If the Supreme Court strikes down Hawaii's version of this law, those state laws are going to face immediate legal challenges. Here's a hypothetical example of what a ruling for the gun owners could mean in practice. You live in a state that currently bans concealed carry in restaurants, shopping malls, and parks that are technically private property. After a Woolford ruling in favor of the challengers, those bans could be challenged in court and potentially struck down. Your concealed carry permit could become valid in far more places than it is today. We already have a preview of this. On the same day the Supreme Court heard Woolford arguments, a federal appeals court, the Fourth Circuit, which covers Maryland and Virginia, issued its own ruling. A divided panel said Maryland's ban on concealed carry on private property open to the public is unconstitutional. 3 judges, even the ones who disagreed on other parts of the ruling, all agreed on that specific point. That is not a coincidence. The courts are aligning. The tide is moving in a direction. Now, here's what most people are getting wrong about all of this. They think the Bruin ruling was the finish line. It was not. It was the starting gun. The real fight is happening right now in 2026 at the Supreme Court. And the outcome of Wolford is going to determine just how far your Second Amendment rights actually extend outside your front door. Here's what you need to do right now. First thing, learn your state's current concealed carry laws. Know which places in your state are currently designated as off-limits, because those are the exact places most likely to be affected by the Wolford ruling when it comes down. Second, if you are in a May issue state that has not fully updated its permitting process after Bruin, consult with a firearms attorney. Your rights may be broader than your state is currently telling you. Third, watch this space. The Wolford decision is expected by late June 2026. When it drops, the concealed carry map of America is going to need to be redrawn. This information has a real expiration date. The Wolford decision could arrive any day between now and June 2026. When it does, the rules change fast. Subscribe to Gun and Gavel right now so you're notified the moment I drop the full breakdown of that ruling, because I will have it live within 24 hours of the decision being published. The next video after that covers exactly what steps you should take in your state based on how the court rules. Do not miss it. Let me bring this all home for you. The 6-3 Bruin ruling was the most important Second Amendment decision in American history. It said that ordinary, law-abiding Americans have the right to carry a handgun in public for self-defense, and that states cannot block that right by demanding you prove a special need. The states hit back by creating massive lists of places where your permit does not work. And now the Supreme Court, with a majority that appears to be on the side of gun owners, is about to decide whether those countermoves are constitutional. Your concealed carry rights are not finished expanding. They are still in motion right now. If this video helped you understand where things stand, share it with one gun owner in your life who needs to know this. And subscribe to Gun and Gavel so you are here when the Wolford ruling lands, because that moment is coming, and it is going to change the conversation about where you can legally carry in America. One final note before I let you go. Everything I covered here is educational content based on publicly available court decisions and legal reporting. Nothing in this video is legal advice for your specific situation. Gun laws are different in every state, and they are changing fast. Before you make any decisions about where and how you carry, please talk to a licensed firearms attorney in your state. That is the only person who can give you advice that actually applies to your exact circumstances. Stay informed, stay protected.